Hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, got a great question today from one of our YouTube subscribers. Hey Patrick, can I continue to give gifts to my favorite charity? Or can I give gifts to my children and grandchildren? And folks, this is a very common subject matter and I cover this quite a bit, but I wanted to be more specific in the context of charities, okay? Because folks, giving gifts can be good if you want to reduce your estate for the Massachusetts estate death tax. For example, Massachusetts has an estate death tax. If you're, say, at $2.2 million, and if you get hit by the bus of life tomorrow, your estate will likely owe money to the Massachusetts Department of Revenue because you're over their $2 million threshold. But if you're like, well, I'm going to give gifts to my children and grandchildren and get under that $2 million threshold, I'm going to give gifts of $300,000. Can you do that? Well, there's gifting rules that apply to that, and typically under current Massachusetts federal tax laws, you can give in 2025 $19,000 per calendar year to an individual, right? So long as you do not exceed that $19,000 gift, then you do not need to file a gift tax return, which is called a 709 gift tax return when you pass away. That 709 gift tax return allows the government to keep track of the amount of gifts that you gave away. Hence the reason why is to give smaller gifts. But folks, we're talking about reducing the estate tax. Today's question is more concerned about long-term care. Hence the reason why I call it a double-edged sword. Good for the estate tax to reduce the estate tax if you have a taxable estate, but it's not good if you become incapacitated and need Medicaid to help pay for your $18,000 per month nursing home. Because the Medicaid caseworker is going to look at and scrutinize all your financial records from the date of your application, looking back 5 years into your past. And when they see that you gave away all that money to your children and grandchildren, that is not good for Medicaid. Might have been okay for the tax man, but not okay for Medicaid because you gave away all your private pay money. And that's an impermissible gift. It's going to create a penalty period, and they're going to say, no, your loved ones who you gave that money to need to cure that penalty and repay those gifts back to you. So you don't want to paint yourself into the corner by giving away gifts to family and anyone for that matter when you're in the fourth quarter of life, when your probability in need for long-term care, maybe Medicaid benefits, is much greater. And I want to let you know, folks, Medicaid does not have a specific exemption for charitable gifts, okay? But Medicaid does say this: if you have a pattern and trend of making gifts, a history of making gifts, and they're for reasonable smaller amounts, Medicaid caseworker, from my experience, may be okay with that. So long as you're making those gifts in good faith and it was for genuine intent to give the gift to charity for charitable purposes, folks. It has to be for genuine intent and not for the ability to spend down to receive Medicaid benefits. That's what the Medicaid caseworker will be looking at. And they'll be looking at things like how much was the gift? What was the timing of the gift close to your Medicaid application? And do you have a past in a trend of making charitable gifts in the past? That would be very helpful to show that good faith and that consistency and that genuine intent. But if you're somebody who never made gifts and now you're over the Medicaid threshold amount for eligibility and you make a significant size gift to a charity to get your financial assets lower to qualify, that likely would be a problem because, again, there is no Medicaid law that allows charitable gifts to be a permissible spend down. So you be very mindful of that. It has to be a bona fide, legitimate charity under Internal Revenue Code 501c3, a legitimate charity and with a tax ID number, all right, for Medicaid to kind of say that is okay, that is not an impermissible gift or transfer of funds. This is the advice I give our clients. This is not legal advice, so this is a recommendation to you. Keep log in a diary, an affidavit of sort, the date of the gift, who the gift went to, and what the tax ID number of that charitable organization is. So 3, 4, 5 years from now, if you or your spouse became completely incapacitated, you can produce that affidavit log diary to the Medicaid caseworker to show that good faith, history, pattern, and trend, and show that genuine intent that you made those charitable gifts long before you or your spouse were incapacitated. So that it is right there, folks. Charitable gifts are not exempt from the Medicaid rules. Medicaid could penalize you for that, but typically they exercise common sense so long as you have genuine intent, good faith, and a history and a trend of that. But protect yourself with that affidavit. Keep something in writing so you have to show that history, pattern, and trend. Folks, there you have it right there. If you'd like to learn more, pick up my books on Amazon. My second book recently, The Top 20 Strategies That Will Help You Win the Battle in Elder Law. Patrick Kelleher. Folks, God bless. Thanks for being here today at elderlawcare.com. Be sure to click that subscribe and notification bell, and we will keep you updated. Thank you so much.